Afternoon. I do want the record to reflect that I had been prepared to start at 5 p.m., but once Christine has laid down the law, I guess our standards have slipped a little bit in the past couple of years as we have not been able to do this, as Christine says. So, good afternoon, everyone. As I imagine that you know, my name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to welcome you to our Lubar Center here in Eckstein Hall and to introduce our Nies lecture. The pandemic occasioned a bit of a hiatus in this series, as with so many things in this world. So we are especially grateful and delighted that all of you are here today for what has been an annual tradition. Let me begin by remembering the person in whose memory this lecture stands. The law school created this lecture series in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit. Even now, a generation after her judicial service and lifetime, Judge Nies continues to be recalled within the intellectual property community as a very generous individual and a hardworking, accomplished, and modest judge. The idea for the lecture came from a faculty member at the time. We are no less fortunate today in our faculty with Professors Bruce Boyden and Kaylee Murray serving as co-directors of our IP program. They lead us not only generally in this realm, but with a relentless and impressive focus on our students and also in helping ensure that each year, pandemic allowing, we welcome a distinguished leader in IP as our Nies lecturer. This year's Nies lecturer has interest and expertise in intellectual property and matters beyond. Jessica Silbey is professor of law and the Yanakakis Research Fellow in Law at Boston University. She teaches and writes in the areas of IP, constitutional law, and law and the humanities. She received a JD and a PhD in comparative literature from the University of Michigan and a bachelor's degree from Stanford University. Her books, published by the Stanford University Press, include The Eureka Myth, Creators, Innovators, and Everyday Intellectual Property. And her topic for today's Nies lecture is Questions of Intellectual Property and Fundamental Values in the Digital Age. I could tell you more about Professor Silbey and her work, but I would rather that you met her and learned from her. So won't you please join me in welcoming to Milwaukee and Marquette University Law School, Professor Jessica Silbey.
Thank you so much, Dean. I'm really so pleased to be here. I have to start and say that because we are still at the tail end of this pandemic, I want you not to worry that the way my throat sounds is anything but my yearly bout of laryngitis. That happens every March at the end of a very long year teaching big classes the size like this, and a combination of the allergy season in Boston. So that is what this is. I don't usually sound so throaty, but maybe it's a good look on me. Who knows? Anyway, thank you so much for inviting me to your school and your community. I'm very, very honored to be here and to focus on intellectual property in the name of the distinguished Judge Nies, whose service to the profession is very notable. I'm also very happy to be here with my colleagues, Kaylee and Bruce, who I've been so pleased to be friendly with, and intellectual colleagues for a very long time. The IP community is a very special place, and they are major contributors to what makes it so special. So the title of my talk is based on a forthcoming book, which is pictured here, called Against Progress. The title takes its subject from the Progress Clause of the Constitution, which gives Congress the power to grant limited time exclusive rights to authors and inventors in order to promote the progress of science and the useful arts. So this project, like so many academic projects, is a continuation of prior work, the work that the dean mentioned, this book called The Eureka Myth. In that book, I sought to understand from creators and innovators themselves how intellectual property works or doesn't work for them in their everyday lives? Is the right of exclusivity an incentive to produce, for example? Is it something on which they rely in order to earn their living? That book was based on over 50 long form interviews that I conducted over the course of 5 years and on qualitative research methods and analyses. And the findings were mixed and complex. But in general, the findings are that intellectual property really doesn't work in the way that the formal legal doctrine and theory says it does. It's not a carrot at the end of the stick for creators and innovators incentivizing production and dissemination. On the ground, from the mouths of the people who are doing and making the disseminating, IP's aim of incentivizing productivity and facilitating creative and innovative work is in fact profoundly misaligned with the experiences of those everyday creators and innovators who do and make their work every day. So that project got me thinking. There's a chapter in that book called Making Do, and that's essentially what many of these folks and their companies do, is they muddle through in a misaligned system. So that project got me thinking, what is the progress towards which intellectual property aims? We can define it in terms of real people and their everyday creative and innovative practices, or can we, should we? This question, I think, is an open question for many reasons. The first reason it's open is because the Constitution is notoriously ambiguous. It's open by design, with the words and phrases intentionally capacious, so that the governing document can, as Chief Justice Marshall said many, many years ago, adapt to the crises of human affairs. What progress meant in 1789 can and maybe should be different from what it means today. Second, the history of the Progress Clause is notably thin. So if we are going to engage in originalism of a kind, we would be hard-pressed to find good evidence from the founding about what that means. And the people who have done very good work on that have basically said it's inconclusive. Third, the legal history of intellectual property regulations since 1789 demonstrates themes and patterns related to sociopolitical and cultural shifts that respond to changes in technology and production, assist the growth of certain industries, and attend to certain powerful stakeholders. In other words, the progress of IP may be situational and historically contingent. And so this project is asking about our current situation. It's offering a trend that I hope is worth thinking more about, given the growing centrality of IP in our digital age. So during the 20th century, we've assumed that IP's goal, so if we look to the 20th century as a model of what we think progress might have been, really what progress was a kind of more, a form of accumulation. More patented inventions, more copyrighted works. And although federal trademark law is authorized under the Commerce Clause, not the Progress Clause, and it's primarily anti-competition regulation, it is also IP. And trademark likewise serves a progressive function, incentivizing the flow of goods and goodwill, in promoting competition in the marketplace. So as with patents and trademarks, we think more trademarks are better, more differentiation, more source identification, more branding, more competition. And we see this progress as more narrative flourishing during the 20th century with the broadening of IP's scope in terms of subject matter rights, remedies, and duration. So for example, the earliest Copyright Act in 1790 only covered maps, charts, and books. Progress of science was reasonably understood to be promoting knowledge of the world, like more maps. This is the map of Boston where I come from, and many of them. In a series of statutory amendments, however, from the middle of the 1800s well into the 1900s, the scope of copyright statutory subject matter started to grow. And it started to include art reproductions, technical drawings, translations, photographs, films, advertising, manufacturing labels, sound recordings. Then, in 1903, the Supreme Court decided the case of Bleistein versus Donaldson, in which it held that this circus poster, which is an advertisement, would also be copyrightable. And it famously said that it would be a dangerous undertaking for persons trained only to the law to constitute themselves the final judges of the worths of pictorial illustrations. And this inaugurated what we call the non-discrimination principle in copyright law, in which aesthetic judgment is left to the market And 120 years later, copyright subject matter covers everything from Yelp reviews, Instagram photos, to shampoo labels. And whereas early copyright of maps, charts, and books lasted only 14 years, that's what the 1790 Act provided, from publication, the length extended from 14 to 28 to 56 in the first half of the 20th century to the author's life plus 50, mid-century, and then in 1998 to the author's life plus 70. So that now a copyright that is fixed today lasts 70 years after the death of the author, and that includes the Yelp review. In patent law, a similar expansion has occurred. Although patent law hasn't grown much in length, the way copyright has, its subject matter has profoundly broadened. Originally, patent law was aimed at agricultural tools like these, and candle making, flour mills, punch types, and printing. These were the signature inventions of an early US economy. The Industrial Revolution then gave way to new machines as inventions, and then famously, buzzing right up to the 1980s, the Supreme Court held that anything under the sun that's made by man can be protected as long as the invention is novel, non-obvious, and useful. And then since the 1980s, patentable subject matter has broadened to include business method patents, parts and improvements rather than whole inventions, as well as genetic material, such as modified human DNA, giving the rise to new social movements around food justice and access to healthcare. Trademark, too, has been expanding over time. We tend to think of trademarks in a traditional sense as words or symbols or other technical devices to signal the source of the good or service. But now trademark law includes packaging and dress, the look and feel of the object, like the shape of the grill or the shape of the thermostat, for example. Trademarks also can include single colors, like the Tiffany, we call it robin egg blue. Trademarks can also include sounds and smells. The roar of the MGM lion is trademarked, as is the smell of Play-Doh. Commercial entities have taken this broad language to heart, the language that's in the Lanham Act that was put there in the middle of the century that says anything that no trademark by which the goods of the applicant may be distinguished shall be refused registration. So anything that can serve a trademark function can be registered. The Supreme Court decided a case at the turn of the century, holding that the festive eating atmosphere of the inside of a Mexican restaurant could be protected under trademark. There are very, very few limitations to trademark protection today. So what kind of story is this plot? What kind of story is this whose plot is growth and accumulation? It's a story that begins optimistically, I think focusing on economic investment and opportunity. It's driven by the idea of a free market. Accumulate lots of IP and the market will distribute it fairly and efficiently. It was born on the eve of the Roaring 20s, hit its growth spurt in the 50s and 1970s when we engaged in major IP reform with 3 new IP acts that were broadly construed by the federal courts. And in the backdrop of this mid-century growth, we have manufacturing, scientific discovery, advertising, entertainment industries, all which are booming around the United States. The 20th century expansion of IP appears as an exuberant race to maximize the benefits of what is a consumerist society, amplifying values that we celebrate still: choice, individuality, abundance, and opportunity. And it's epitomized like places like Times Square, pictured here. So by the 1980s, with the arrival of the personal computer revolution, it is fair to say that IP was doing exactly what we thought it was supposed to do, promoting progress as capital growth with dreams of wealth and comfort for businesses, certainly, and many individuals as well. Now, the internet revolution disrupted that trajectory. The transformation of civil society in the digital age, it turns out, is an existential threat to intellectual property that aims to control the making, innovating, and distribution of works except by authorized manufacturers. IP law's exclusive rights of control over making and using is an exception to freedom. And yet the internet and the creativity and innovation it has enabled is defined by the generativity and the copying by all of us. Rooting around roadblocks that IP erects, or that it tries to, is one primary way the internet and its users both work and play. Now, lest we think this has no precedent, before the internet was the copy machine, the tape recorder, and the VCR, also threats to intellectual property law. And these devices were almost sued out of existence. So fearful were we that their copying technology would make books, music, and movies disappear because they could be so easily pirated. But instead, in very close Supreme Court cases, these decisions were allowed to survive. And with it came new technologies, new copying machines, new business methods for making and innovating, some considered threats to IP's protection today of patented technologies, copyrighted works, and trademark goods. But as with the copy machine, which has become essential to education, research, and business, we cannot live without the internet. It's here to stay. The internet may be an existential threat to IP, but it does not stop any of us from right-clicking and copying and sending that photo or file over email or Twitter, which could be copyright infringement. It doesn't prevent us from repairing our phone or our computer or our car, which could be patent infringement, or from making a hospital fundraiser t-shirt punning on a famous brand name, which is most certainly going to be trademark infringement. All of this behavior, which is inevitable in the digital age, which some would call a kind of progress, but also some would call a form of piracy, challenges the rules of IP law and causes a form of legal chaos. And this has caused me to wonder, actually, if IP as historically understood and justified is set to change dramatically in the 21st century. And it causes me to wonder, what is IP for today? So in addition to the internet's ubiquity today, there are several reasons I actually think that the stage is set for this change. Now, first, since the mid-1990s, interestingly enough, the Supreme Court has decided to take intellectual property cases at a rate that is more than double its previous rate. The highest national court is a tone setter, and it selects content and focuses our debates among legal elites and lawyers around the country that reverberates to the national media and the public. The Supreme Court is, in other words, a narrator of national values, interpreting federal and state law in light of the US Constitution and its general democratic and procedural values. So when it interprets and applies IP law as frequently as it is doing today, it's shaping those IP laws in terms of national values and practices. And this, I think, is one way IP law is changing and how it works. The second reason I think we can see this impetus for change is that intellectual property, there are a lot of IP lawyers in the room, I realize. And so I hazard a guess that when you went to law school, there weren't a lot of full-time IP lawyers, IP faculty. When I went to law school, and I'm still 27, there was only one full-time faculty member. But now, today, it is the center of IP, it is center of law schools all over the country, that law schools are falling all over themselves to develop law and technology centers, building these programs, centering and highlighting the importance of the field to contemporary legal practice. I mean, Kaylee and Bruce and I were talking about, we know we can now have enough IP law professors in our faculty, given the demand among our students. It's such a prevalent legal field, in fact, that it's not only in law schools, but it's in business schools, it's in other graduate schools, humanities programs, it's even sometimes in undergraduate and high school. So the third, I think, mainstreaming of intellectual property leads it from an obscure corner of the law to a public consciousness that even teenagers acquire, transfiguring copyright and patent and trademarks into a subject of everyday importance. So today, it's really unexceptional to see it on the front page of the headlines, for example, all forms of IP. I got so many calls about LeBron James and his Taco Tuesday. So this mainstreaming of IP, of what I sometimes call a domestication of intellectual property, affects popular conceptions. It's in our TVs as well, our TV shows. And the popular conception of creativity and innovation, and thus the demands on the law that it's regulating, that it's becoming part of our everyday consciousness. New stories are proliferating, I think, about intellectual property because of its saturation into ordinary everyday life. New stories. So where we might, in the past, in the 20th century, the domestication, or the democratization of markets and more IP was really about markets and money. It was about creating the markets in those intellectual works. Today, the domestication is really, I think, about fundamental values like these. The mainstreaming of IP has brought these constitutional values to its core, and that, I think, is what we're debating when we talk about IP today. Now, you may be skeptical. So let me tell you where I'm getting my data from this, why I think this is true. So there are two buckets of data. One is a bunch of court cases, and I mean like thousands of court cases that I have in binders and discs, or on thumb drives. Shows how old I am. I'm not 27. Okay, and interviews that I've continued to conduct over the course of since the Eureka Myth was finished. I did many, many more. So I have court cases that I'm analyzing and more qualitative data. So let me talk to you about the cases first. This is Naruto. Naruto's a macaque monkey from Indonesia, and she took this picture herself. It's a monkey selfie. This is David Slater. He's a nature photographer who set up the camera and encouraged the troop of monkeys to play with the equipment. So David did this because for weeks he couldn't get a close-up that he was happy with. And so he set up the camera and lured the monkeys to the machine. And eventually they ended up taking a lot of selfies, actually. David published these photos and sought to license them. But then PETA, the Protection for the Ethical Treatment of Animals, sued him, arguing that the monkey and not the man was the author of the photo. So, there is something very humorous about this. But this lawsuit got a federal judge's attention. It required significant money spent on both sides to convince the court, and eventually also the Copyright Office, that only humans can be authors. Why is that so obvious, though? So that's what I wonder. PETA brought this suit to assert the dignity of the animal in the way that authorship provides, as an expression of will in the world. PETA asserted not that monkeys are human, but that maybe they should have some basic rights like humans. So can children be copyright authors? Yes, they can. Can corporations be copyright authors? Yes, they can. Capacity in a human body is not a necessary prerequisite. Can artificially intelligent machines be authors? We're actively debating that today. So these debates are about what it means to be treated equally, with dignity, not necessarily as humans, and not only under copyright law, but generally, I think, and especially today, when the planet's natural resources and all forms of precarity are growing scarce, when empathy and cooperation and mutuality is necessary to survive. The next IP case is about privacy, bodily privacy as it happens. So this is Cindy Lee Garcia. She auditioned for and performed a small part in a film. She was told it was called Desert Warriors. Her performance was only 5 seconds, and she only had a couple lines. She was paid, and then she went home. And then months later, the film was posted on YouTube by the filmmaker, and Garcia's voice had been dubbed over with hateful anti-Muslim slurs. The film was now called Innocence of Muslims, and it was not an action film, as she was told it was, but a despicable screed against Islam. It was viewed millions of times over YouTube and seen all over the world. She got death threats and had to hire professional security. When she asked YouTube to take the film down, they refused because she was not the copyright owner. The filmmaker was. And that's true. An actor's performance in a film does not create an independent copyright. The filmmaker is the author of the whole film, not the actors, not the set designers, not the lighting experts. And the only way to get the video offline was to allege copyright ownership, which she could not. This case went up on appeal twice because the issues were so dramatic and the equity so concerning in the Ninth Circuit, creating splits in the decisions among those judges. The filmmaker was outside the jurisdiction of the United States, and YouTube stood by its policy, and only the copyright authors had control. Google prevailed. So this case is really not about copyright either, I would say. It's about Garcia's bodily autonomy, her privacy as a person invaded by the misrepresentation and fraud perpetrated by the filmmaker. It's also about the exacerbation of that privacy invasion by platforms like YouTube, Twitter, Google, and Facebook, and Amazon, whose policies prioritize efficiency and growth over other values. Now, IP and privacy are often at odds. IP aims to disseminate knowledge and the useful arts, and privacy aims for seclusion over identity and one's life choices, control over identity and one's life choices. So some copyright cases in which estates of famous authors like James Joyce or Willa Cather, for example, sue to prevent the publication of private letters or unpublished manuscripts. Those are properly within the scope of both copyright and privacy. These are cases about papers and effects, private thoughts that were undisseminated. And we know that privacy in the United States extends to our papers and our things, our private homes. That's the Fourth Amendment's promise. So using copyright to prevent publication like this of these kinds of private literary works makes sense. And the author's estates, they often prevail. It's usually the heirs or the estates who sell, much to the consternation of literary historians and scholars. But they are nonetheless uncomfortable cases because copyright is supposed to promote the progress of science, not protect the privacy of public figures, but whose heirs wish to hide their writings, I should say, as long as copyright endures, which is a really, really long time. But what about cases like this one? So this is Hill versus Public Advocates, in which a photographer makes a photo of a couple's engagement, here, two men, and posts it to her website with their permission. So then an anti-marriage equality group scrapes the photo from the website and reprints it in their literature to criticize gay marriage. How should this case come out? Using someone else's published work to criticize its message is usually permitted under copyright fair use as a form of free speech under the First Amendment. But when the couple and the photographer sued alleging copyright infringement, but really it's an invasion of their privacy and the right to control the representation of themselves to the public and their defense of marriage equality, the courts were listening. This case got so far to trial, actually, that the defendants settled and took the photo down from their website, from their campaign website. So we may be sympathetic to the couple and the photographer, I mean, at least I am, but this is a blow to free speech. And this is not the usual copyright case, which worries about market substitution and lost revenue, for example. This case ostensibly is about misappropriating someone's identity, which is squarely a privacy concern and typically not a copyright concern under US law. Okay, so now for something a little different. This is the band Boston. And in 2015, the case of Schultz versus Goudreau reached a peak. It was a dispute among the members of this 1970s and 80s rock band Boston. So for fans, rock and roll fans in the audience, I'm always a little, I'm not gonna sing for you, but Boston was known for hits as More Than a Feeling or Peace of Mind. It was a big band in the 70s and 80s. And after breaking up in 1981, the former band members started fighting over who could properly use the trademark term Boston to continue to refer to themselves. The issue was the lawful use of the trademark without confusing audiences about who was and was not a founding or former band member. So Tom Schultz and other Boston band members sued the guitarist, Barry Goudreau, to prevent him from describing himself as the original founding Boston member. And they harnessed trademark law to do it. Negotiations in the lawsuit painfully lasted decades. Schultz sought to limit Goudreau's designation to formally of the band Boston and limit all other ways of describing his affiliation with the band. The trademark question, the doctrinal question, was could Goudreau be prevented from referring to himself instead as a founding Boston member? The plaintiffs alleged false designation of origin, false and misleading description of fact. These are words in the trademark statute, to be sure, but they're most often used to combat false advertising and consumer confusion. Trademark law is not usually about negotiating breakups like this. So this is an unusual case, and it went to trial, and Goudreau won. He won the ability to designate himself as he pleased. And in August 2018, an appellate court finally affirmed the jury verdict, but it spanned 3 decades, cost hundreds of thousands of dollars. And to me, the dispute confirms that intellectual property is an important but imperfect framework in which to negotiate the terms of affective relations today, which is a feature of privacy law. Finally, I don't know, has anybody heard about Farmer Vernon Bowman from Indiana? I know Kaylee has. This is Bowman. He sued Monsanto, the seed giant. Monsanto has a patent on a special soybean seed that's called Roundup Ready. Plant it and fertilize it with Roundup fertilizer, and your soybean will be super resistant to crop destroying diseases. Bowman was a fan of Monsanto. He'd been buying Monsanto seeds for years. And buying the seed came with a license to use the patented seed, just like buying your cell phones comes with a license to use the cell phone and the patented technology in it. Farmer Bowman was allowed to use the seed as seed, plant it, and sell it as soy. But like many farmers, he planted the seed to both grow and sell as soy, as food, as well as to grow and use as seeds to replant for the late harvest crop, which is usually very risky. So planting patented seeds produce soybeans and more seeds, seeds that contain the patented invention. The very act of farming was a form of patent infringement, copying the invention which Monsanto permitted once under a license to plant and sell as soy, but not again to replant as seed. Now, the late season crop is very risky, as I said, and so investing in more seed makes that investment even riskier. Saving seed is something farmers have done for centuries. What Monsanto's lawsuit did was interrupt that practice with the claim of patent supremacy. Now, Bowman's claim against Monsanto goes like this: I've paid for the seed and its invention once already. You got the benefit of the bargain, and as all patentees do when you buy patented inventions. No one can sell Monsanto seed, but that's not what Bowman was doing. He's just using the seed he lawfully purchased. In response, Bowman says that growing seed to plant, not as soy to eat or sell, but to use as seed, is an unlawful copy, is making of an unlawful copy of Monsanto's patented seed. In other words, Bowman replaced Monsanto's seed with his own and therefore cuts into Monsanto's monopoly. The only way out of this debate, I think, really, is to realize it's about distributive justice. It's about fairness in the patent system. And it's an argument about the rightful reach of patent monopoly and when, frankly, enough sales are enough. On the one side is a giant agribusiness that owns more than 92% of the US soybean acres. And on the other side is Bowman, who struggles to make a living as a farmer. He lost this case. The Supreme Court said there's no exception to the patent monopoly, even for inventions that self-replicate. And yet the arguments that Monsanto's gross and imbalanced rewards profoundly interfere with age-old, sustainable, and frugal practices among farmers really has resonated with a lot of people. And the movement to free the seeds, for example, and diversify agriculture from within intellectual property actually is growing. So these are patent disputes that concern distributive justice as a form of human flourishing. And these are some of the cases, I think, that indicate the turning tide in what IP is for. So now for the data. Less pictures and more text. Are you ready? Okay. So in my interviews I conducted many, many interviews, and I'm happy to talk about how and who and all that stuff. But I heard various themes that I want to share with you that go to this question of progress. So specifically, when I asked creators and innovators what they would do to change intellectual property law to facilitate their work, most of them described flaws in the system as being deeply out of balance, as being plagued by incumbency biases, and suffering from a breakdown of civility norms. So to most everyday creators and innovators, the IP system thwarts progress instead of promotes it. So they tend to live by other rules adapted to their own practice, like Bowman did until he got caught. And in fact, most artists and scientists that I interviewed, and the small and big companies of which they were part, are much more generous than the IP system strictly enforced would allow. They're okay with lots of forms of copying and borrowing that the IP system would really not permit. So, for example, a singer-songwriter, she says, a total copy ripoff, that's not great. But if someone's just taking parts, not being influenced by it, and being influenced by it, that's great. Or inspired in some way, it's all this big pool, and we're throwing stuff into it. So if someone is being inspired to write something by it or stealing an image, that's unavoidable. Everyday creators and innovators, they seek to do their work and enable others to work as well. And so for them, the benchmark is a kind of mutual flourishing, not a winner takes all. So a central principle is that most creativity and innovation is actually expected to be built from other creativity and innovation. It's built upon a kind of copying, which is why copying technology is so prolific. So one person said to me, a software programmer would consider it malpractice in their field to create a program from scratch if there was a perfectly good set of algorithms laying around that they could use. It's tried, it's proven, we know this thing is bug-free. Of course we want to use that one. This was way before Google versus Oracle, by the way. So the Supreme Court affirmed this idea just last year. These folks are explaining how copying and borrowing is essential to the work being done. And so a lot of the times they ignore the IP rules that restrict borrowing and sharing. These accounts describe a much more tolerant and more generous regime in which public domain is richer and is bigger. And this actually resonates, I think, with the original meaning of the Progress Clause in the Constitution, its goal in knowledge dissemination with an original scope of subject matter that is much narrower and much shorter. So overly aggressive assertions of IP really bother creators and innovators. And they sometimes are described as violent, they're described as uncivil, suggesting a breakdown, as I said, in community and social norms. So for example, an internet entrepreneur said that all these companies that I work for, we file all these patents, and we're sort of cynical about them. We don't think these patents are really necessarily going to ever be worth anything, except in this whole morass that is people wagging sticks at each other, saying, I'm going to sue you over your patents. Company executives describe the threat of patent litigation as a shakedown, beginning with unsophisticated small companies that don't have a lot of patent experience. They really identify the weak links in the chain and go after them. In other words, they say those who have the bigger stick, who can withstand the squeezing, will survive the threats. Some creators and copyright defendants that I talked about described coercive contracting situations in which more powerful party takes you hostage, like a feudal lord, exerting control because of rapacious tendencies to protect their incumbent position and minimize their own risks. This was about the music industry. So these are stories about how winners are foreseeable, capitalized incumbents and intermediaries, and how the system doesn't seem fair or open to all, how threats generate an unjust order. So to everyday creators and innovators, IP strictly enforced is more like a rule of law for the powerful than a rule of law for the many. And thus, unfortunately to them, the system seems illegitimate. This is a story of institutional breakdown, I think, the opposite of what we'd hope the rule of law promotes, which is institutional inclusivity and resiliency. And so when these harms, we'll often think about IP in individualized terms. These are not individualized harms. These are complaints about systemic dysfunction and a breakdown in the organizational integrity of IP. And in these interviews with what's wrong with IP, I did not hear, for example, zero-sum contests where for one person to win, the other person has to lose. Instead, I heard descriptions of how IP works optimally in more interrelated and system-level analysis. Despite the importance of being called an author or an inventor, for example, everyday creators and innovators appreciate the structural mechanisms through which their creativity and innovation flourish or is thwarted. And they appear to appreciate that these structures are interactive and interdependent, and they depend on the relationships which IP can constitute as a system, but is failing to do it today. Many of these descriptions contain images of power, imbalances related to size and influence, rather than to quality, for example, of the work done or value to society. Now remember I showed you the circus poster before. That circus poster case got rid of the idea that judges judge quality, right? So here we have lots of creators and innovators thinking we wish IP would promote quality. The question is, who judges that? They describe how financial rewards are not distributed proportionally, for example, based on quality or who's doing the work. Instead, who gets ahead are not necessarily those who made the work, for example, but intermediaries or lucky acquirers. So, for example, a film producer, I talked to a bunch of film producers, describes frustration with platforms and databases that contain photographs that they're unable to access because the databases or archivists are not letting the photos be used in the film as raw material. She says, it's rare that the person that actually took the photo still owns it and holds it and is selling you the rights. Extremely rare. Most common is collectors or historical societies who often have been given the material for free. So imagine, this historical society having all these old photos, who are insisting on getting paid for it to be used. She says, I can understand paying for copying costs and paying for processing, but oftentimes the pay goes way beyond that as a money-making venue. A different filmmaker I interviewed described how she's not disappointed necessarily in copyright or the rules of it, although those are difficult. What she says is what's disappointing is that people control access to those images so that even if they don't own the copyright, so if you're the archivist, you might not own the material, for example, they cannot legally restrict the copyright, but if they own the image, they can restrict you making a copy because they control access and hold you hostage for an inordinate amount of money. So harmful effects of this precarious legal system with these characteristics is that products are slower to arrive, maybe more costly to make. And the filmmakers talked to me about how the quality of them is compromised. Not being able to include the photos in the films compromised the film quality. So they talk about plaque in the arteries of creative and innovative enterprises lead to inefficient workarounds, for example, lower quality products, bad patents, hold up industries, we've heard that. And instead of new stories, this was interesting to me, they say there's a lot of remakes rather than originals because those rights are easier to clear. These IP rules are not producing innovation to many creators and innovators, they're producing waste. So these are not individualistic complaints, I don't think. They're complaints about a system and about institutions. It's important, I think, because it's a structural critique. It's a critique about how capital is working in an IP world, how labor is being valued, what counts as value, and who has a fair shake at sharing at the profits. These are common themes in our current 21st century. And if I'm right about this, about the notion of harm being more systemic than individual, then the unit of measurement and the analysis in IP should be at the system level, not at the individual, and progress should be measured in terms of social welfare and the public good, not as an aggregate of individual preferences. So doing so, I think, would go a long way to thinking about shared fate in the digital age in terms of creativity and innovation that we celebrate today as being made more possible than ever before. So court cases like these, along with the interview data from the creators and innovators, I think challenge us to rethink what IP is for and how it's changing in the internet age. They raise the specter, I think, for systemic reform to anchor the goals of progress of science and the useful arts and the enrichment of the commonweal and shared values that sustain us. So in conclusion, what do I make of this? So I think there are 4 takeaways, basically. I think this is evidence of a growing critique of the digital age's promise to make us more equal and more free. I think we thought with all this technological progress, we expected welfare maximizing regimes, but instead we see dramatic wealth inequality and labor precarity. I think we had hoped that the information age would spread democracy, information. Instead, we get a lot of fears about demagoguery and breakdown of democracy. I think it's undermined the modernist story of progress with its narrow, I think, market-based metrics that exposes competing claims to the common good and to justice, which I think could be a helpful conversation to have. So I think these new stories about our IP are really their moral narratives, urging us not to outsource our values to markets. These new narratives seek an ethical consensus about what we should be caring about when we care about IP and other legal regimes like that. They're also about the rule of law, for sure, about the rule of law, that it's its purpose to preserve fundamental democratic values such as equality and privacy and distributive justice and institutional resiliency. through laws' features of accountability and transparency and proportionality and nonviolence. And I think they're helpful. These are helpful ways of thinking about what progress is and what progress is for in the 21st century for intellectual property law. And it's also, of course, I think, as we come out of this pandemic and can come together again, it's about thinking about our shared fate and interdependence on the planet and how intellectual property can contribute to that. Thank you very much.
Can't imagine that you couldn't hear me there, but let me say it again. We do have time for questions, and so if you have one, if you want to raise your hand and signal, and I will recognize you in some sense. Yes, please.
Any thoughts on NFTs?
Hmm. Oh,
That's just a vague.
yeah, no, right. Who's not obsessed with NFTs right now? Right. So I have lots of thoughts about NFTs, but I think one of the things that NFTs are doing is exposing sort of sometimes the hypocrisy and the irrationality of the art market, for example, like who benefits from that. I think that's one way of thinking about it. It's also a form of, I mean, it's low access at some level, but not incredibly predictable. And we're already seeing stolen NFTs. We're seeing uncertainty on the blockchain. So I mean, people are thinking the NFT is the end of art. But, we've been saying that for a long time. So I think cryptocurrency and NFTs as a form of crypto value is an interesting way of it's another form of democratization, but it's really only accessible to those people who know how to it's called minting an NFT. I actually tried to set up a crypto wallet a couple months ago. It's not that easy, actually. So I think it's both a resistance to conservative forms or traditional forms of making, at the same time is an access point for people who have felt left out of that hierarchical art regime. And for sure, we're seeing people who are benefiting, young artists, old artists, who are benefiting who felt like they couldn't. So I think it's an interesting flashpoint for questions of hierarchy in the art market and value. Like, why would anyone buy an NFT for $68 million? But you could ask the same thing about a Warhol. I mean, you could.
I mean, that's what I think it seems that's a fulcrum of what you're saying.
Yeah.
You got the full law for the public.
Yeah.
But then on the other side, you have a market that creates the value.
Yeah. Right.
And then it kind of shifts.
Right. There's another thing about NFTs. I want to give other people a chance at, but NFTs they promise to be truly unique. So where all art can be replicated, and there's all the worry about piracy or what does it mean to own the original something. NFTs, theoretically, there's only one part. The ledger is unique. But of course that means that the thing that the ledger is attached to, which is the image, can circulate freely. So there's this other interesting aspect of NFTs where the artists don't care if you replicate the image. All that they're selling is that one ledger. But so that's just a replication of uniqueness as well. I mean, it's a different kind of uniqueness and scarcity, and which cannot be duplicated. So it resists the internet's generativity in that way as well.
I mean, could that have an implication for the coding?
The coding.
How you were saying, like the computer.
Oh.
Like how software.
Yeah.
Writers.
Right. With the bugs. Yeah, I actually think that I don't have any reason to think that NFTs aren't going to go the same way that anything else does, which is.
What I'm saying is hey, I coded this.
Oh.
It's right here on the ledger.
Yeah.
And now you are using what I coded.
I don't think it works that way. That ledger, it's truly a unique on the blockchain. There's only one.
I'm saying, but
let's take another question. Partly because I don't know what NFTs are.
Oh.
Non-fungible tokens. I get
right?
it,
Come on.
Yes, please.
In your interviews, the impression I got is you talk to the creators, so the inventors and the authors. But isn't it also important in the IP system to talk to the people that invest in the development? Like a lot of inventions, they aren't like the better mousetrap. If somebody doesn't invest in the development of the invention, it never comes to benefit anybody. And I
Yeah.
think that's probably also true in the creative works.
Yeah.
So did your interviews include investors?
So they included the business partners who were investing. So the company, I apologize. I really only quoted from individual people, although there was a CEO on there too. So I did interview. My interviews were stratified for qualitative validity of people who were the individual makers and people who would otherwise be owners or aggregators, or like whether they were companies or platforms and things. So I did interview. And I have to say, one of the things that surprised me about the interview, because my hypothesis when I went into this is that I thought that the owners who owned many patents, for example, were going to speak differently about the patent system than the bench scientist. And they didn't. They actually sounded very, very similar. And in fact, a lot of the business owners, whether I was at many like pharmaceutical companies and electronic companies, energy companies, they were more upset about the intellectual property system. I mean, the arguments about the patent system going after the weak links were their experience. I mean, multi-million-dollar businesses being sued by what they called were patent trolls for money. It was a useless lawsuit. Yes, maybe I'm technically infringing, but that patent is a bad patent. So we had to build up our litigation firm to defend against this because we're not gonna cave to this guy. And so a lot of the companies did express profound frustration. And the filmmakers were also talking about the film companies. So the interests are interestingly aligned, actually. And of course, when you do this kind of research, what's hard is I'm only ever interviewing people, right? So I'm only interviewing the CEO or the vice president or the bench scientist. So they're speaking as people, but when I asked them, I said, I need you to think about the interest of the company. I want you to talk, I know you're a person, but I want you to talk about as the corporate owner. And they said, I wouldn't say anything different, but of course, it's still a person I'm talking to. So it's hard to, part of what's interesting is there's theory, there's economic theory, there's theory of the firm, there's microeconomic theory, there's all these theories, but then none of that really came out in these interviews as much as I tried very hard to elicit it. And I was a good litigator. I know how to cross-examine, but so it was a surprise actually to me.
Thank you. Next question in the back. Yes, please go ahead. No, that's you. Yes.
Thank you. So I have not taken any IP courses, so I ask you all to bear with me. So
You're
this
in good
lecture
company
is
here, but go ahead.
Yeah.
this lecture is titled "Questions of Intellectual Property and Fundamental Values in the Digital Age." How do the answers look like?
What are the answers to what the values are?
Yes.
So the values are broad values: equality, privacy, distributive justice, and institutional resiliency. Now, those are not uncontested values. It's not like we can't argue about what equality means or what privacy means. So my other hat in the law school is I teach constitutional law, as the dean said, and so I spend weeks debating what equality means and what the contours of privacy are. But it's very weird in intellectual property law, being an intellectual property teacher, to talk about equality as a motivating value. And I'll just give you an example. So there's an infamous case called Golan versus Holder in the copyright space, which is about foreign authors who lost their copyright because of a change in the copyright statute in the late 90s. And what that change in the copyright statute did is bring back all of these copyrighted works that were previously in the public domain in the United States. So Prokofiev's Symphony, Peter and the Wolf, some of Escher's, some famous stuff that were in the public domain that we had all sort of relied on as being free. And this part of this copyright statute added by Congress put them under copyright law for another many, many decades. And there was a big outcry for that because it created a lot of expense for small orchestras and teachers who were usually, and publishers now had to clear all those licenses. It was hundreds of thousands of work. It went all the way up to the Supreme Court on a theory that was a violation of free speech and that it was an irrational use of the copyright statute. And the way that case was decided by the Supreme Court is written by Ruth Bader Ginsburg, who I don't know if you know, is famous for her equality jurisprudence. She and famously also very, very likes copyright a lot, likes strong copyright. She said that the way we explain that bringing back all those works and putting them under copyright is treating the foreign authors equally to the US authors. It was a form of remediation for discrimination that those authors had experienced under the previous regime because they were denied copyright for lots of reasons, but many of which is because they were foreign authors. And so that case, you read it as a copyright case, and we teach it as a copyright case about the rationality of copyright law and promoting the incentive and stuff like that. But it's really an equality case. It's an anti-discrimination case. So that's an example. So that's one of the values that animates these cases that we teach on the one hand as doctrinally copyright, but if you just flip it, you see it's really about equality.
I think we have time for one more question, if there is one. Yes, in the back. We're going to get you a microphone.
Hello.
Hi.
Thank you for being here today. So to kind of continue along the theme of unanswered outstanding questions, as the media in which we use copyrights and intellectual property grows, for example, Internet 2.0 and the metaverse and what have you, similar along to the previous question regarding NFTs, we've also established today that the purse strings around the ownership continues to tighten. So what would you see as like the appetite for reform in this area? What are your thoughts on everything coming to a head, perhaps in a series of landmark cases, or what do you think the resolution will look like?
Well, that's a good question, and I hate ending on it depends. I don't know, like classical lawyer, but I'll just say that so Google versus Oracle last year was a really important Supreme Court case that between two giant competitors that blessed the taking in order to facilitate more productivity within more generativity. So I think I think if we're talking about just Supreme Court, I actually think this Supreme Court, while potentially, and this is now my disastrous on certain issues, maybe election or reproductive justice, may actually be pretty, what I consider progressive on intellectual property law. I actually see Justice Roberts and Justice Roberts largely in some of his opinions suggesting some skepticism that IP has gotten too bloated. So they may be, and in a textualist turn, like in the Supreme Court going textualist on us all the time, there's a lot of room to narrow it down. Like the text of these statutes is actually not as capacious as the Federal Circuit, for example, would read into it. So I think the Supreme Court might actually add that. If we're talking about legislative reform, we do see small claims courts being created in copyright and maybe in patent, which might actually benefit smaller users at some level to get some recompense without having to sue or be sued. That is dispute resolution in the way we think about domain name disputes, which really did work. We're also, though, seeing a lot of movement on the trademark reform. The Trademark Act, I think, it already was reformed a little bit. There has been a lot of empirical evidence that the trademark system and the registration system is full of fake specimens and clogging up. I don't know if you've searched on Amazon and saw, your top search is like brands that don't have brands but just have long numbers, for example. And those actually are registered trademarks as arbitrary, as fanciful marks, which seems ridiculous because it's not actually a mark at all. And the question is, how do those get through the trademark office and who has filed that? So it turns out, from a national security perspective, it looks like those are a lot of foreign filers. And so the Congress has actually unified around the possibility of trying to fix that problem, which I think creates more access for small businesses and small trademark owners, which I think is what really it's supposed to do. So I see that being the most fruitful in the legislative agenda.
So let me say three things. One, as Christine announced before the lecture, we do have a reception right outside in the Silbey Forum, and I warmly invite you to stay. And if you do have additional questions, you can press them upon Professor Silbey. Second, I want to thank all of you for coming back, as it were, to resume our distinguished lecture series. This is so exciting to be able to be together again in an intellectual community. And third, and scarcely least, warm thanks in particular to Professor Jessica Silbey, who has resumed our distinguished lecture series and, in a great tradition, delivered a most interesting and challenging Nies lecture, not least because I now have to go out and learn what NFTs are. So we have our topic for dinner. So thank you so much.